back, and this is the second video in which we're actually going to analyze the sexual abuse claim made by Heather Williams against R. Kelly. Now, I have to admit that this is some pretty confusing stuff. I found the statute in question, Chapter 735, Illinois Compiled Statute, Section 513-202, right? Now, here the statute is here, and I have read it, and I have to admit up front, this is some pretty confusing stuff. It's very complex. It's very confusing. And if any of you out there are really good at reading statutes, or you're just really good at understanding things and breaking them down, I welcome you to read this statute and basically make a video on this statute and explain it to the rest of the community, because I have to tell you up front, I do not understand it, right? So again, I'm not a lawyer. I didn't go to law school, and I'm not licensed to practice law. I'm basically doing this video under freedom of speech for the purpose of education purposes only. So if you can help educate me and the rest of the community, please make a video on this statute, because I cannot understand it. So I did read it. It's pretty long, and basically I broke it down and I highlighted what I thought were the pertinent parts. So let's just go ahead and get into it, right? So chapter 735, Illinois Compiled Statutes, section 513-202, basically goes to say that childhood sexual abuse means the act of sexual abuse that occurs when the person abused is under 18 years of age, right? So if you have sex with a person under 18, you committed childhood sexual abuse, right? If you're an adult, right? Notwithstanding any other provision of law, an action for damages for personal injury based on childhood sexual abuse must be commenced within 20 years of the date the limitation period begins to run under this section D. Okay, so now this is where it's going to start to get really confusing, because according to this, there is a 20-year period, or a 20-year limitation period at which you could bring such a claim, and basically it's going to go into that in section D, right? But let's just keep reading. Or within 20 years of the date the person abused discovers, or through the use of reasonable diligence should discover, both that one, the act of childhood sexual abuse occurred, and two, the injury was caused by the childhood sexual abuse, right? So it looks like this is an alternate condition. Basically, it's saying that if, from what I understand, again, this is confusing stuff, but from what I understand, you have 20 years. When you discover that you've been sexually abused, you have up to 20 years to bring this claim. Now, the other part of it is that if you were diligent, you should have discovered that you were damaged through sexual abuse, and you have 20 years to bring the claim. So to me, I interpret the section that talks about diligence to mean that if you're a reasonable person, a reasonable responsible person, you should know at a certain time that you have been damaged by sexual abuse. When this occurs, or when this should occur, I don't know. I'm not a sexual psychologist. I'm not a lawyer. I don't know when you should know that you've been discovered, I don't know when you should know that that you've been damaged by sexual abuse. That is really confusing, and it didn't come out really the way I wanted it. But basically, I guess what I'm trying to say, there is such a time, according to the statute, that a reasonably diligent person should know that they've been harmed by sexual abuse. There you go. So, all right. So, moving on. And basically, the fact that the person abused, discover, or through the use of reasonable diligence should discover that the act of childhood sexual abuse occurred is not by itself sufficient to start the discovery period under which this subsection B, knowledge of sexual abuse does not constitute discovery of the injury or causal relationship between any later discovered injury and the abuse. Jesus Christ, I'm not even going to try to break that down and understand it. If you people understand it, please explain it to me. Um, and then I've highlighted uh, that the last act of childhood sexual abuse in the continued series occurred, and that the injury was caused by any act of childhood sexual abuse in the counting of the series. So basically, when I read this section for the first time, to me, I understood it to say that, like, maybe you have been abused at 12, and the abuse continued until you were 17. I think what this section is saying, that the clock doesn't start ticking until the last date that you were sexually abused, which in that example would be 17. Again, I don't understand this stuff. Hopefully someone can find this statute and read it to me and explain it to me and explain it to the rest of the community so we can all understand, because we all want to understand this statute and what in the heck they're talking about. Um, then I've also highlighted the limitation. This is D, which was referred to above, right? Which is going to talk about the limitation periods to begin to run under subsection D. So this is going to talk about the time period, which is going to talk about when the clock starts ticking after the sexual abuse, right? So the limitation periods under subsection D do not begin to run before the person abused attains the age of 18 years of age. And if at that time the person abused attains the age of 18 years, he or she is under other legal disability, the limitation period under subsection B do not begin to run until the removal of the disability. So basically, from what I understand, the person has 20 years after age 18 to bring this claim. But if at 18 they get hit in the head with a rock, or they fall down and they break their neck and they're in a hospital, then the clock doesn't start ticking until after, I believe, they recover from the disability. So let's say you've been sexually abused up until the age of 18, or it doesn't even matter. So let's say you were sexually abused as a minor, and then at 18 you fall down the stairs, you get hit by a car and you're in some type of horrible accident, or you mentally become disabled, then the clock doesn't start ticking. That 20-year clock doesn't start ticking at 18. The clock starts to tick when you actually recover. It continues, notwithstanding, and this is a part I really don't understand, but I think I highlighted it for a reason. Notwithstanding any other provisions of law, an action for damages based on child sexual abuse may be commenced at any time, provided, however, that the changes made by this amendatory act of 98 General Assembly applies to actions commenced on or after the effective date of this amendatory act of the 98th General Assembly, if the action would not have been time barred under any statute limitations or statute of repose prior to the effective date of the amendatory act of 98 General Assembly. Okay, so this is the part where I'm just going to admit that I am a blundering idiot, because I kind of don't understand what they're saying here. I think maybe if I think about this for like an hour and read it about 100 times, I could get it. But I know that it's important, because this section is basically saying that this act has been amended. So, from my understanding, if the act has been amended, then it's going to become an issue of which version of the act applies, right? So does this version of the act apply, or does an older version of the act apply? Now, when it comes down to the actual claim, it's going to be interesting to see whether or not, and I don't want to talk about this too much, because I want to talk about it in the last video when we talk about potential strategies. But it's going to look like there's going to be an issue of whether or not the court is going to have jurisdiction, because, or whether or not R. Kelly's due process rights are going to be violated. And I say this because if the plaintiff's claim has expired, right, then she doesn't have a claim, right? So basically, if you can remember back when we read the actual lawsuit, I think she said the sexual abuse started in when she was 16, which was May 26, 1998, right? And then I think in 2000, she became 18. Well, if I'm correct me if I'm wrong, but basically we're looking at the statute of limitations are very close to it because basically this started in 1998, and basically she's bringing this claim now in 2019. So it looks like she may have made it by 1 year. I'm not sure because again, it looks like the clock doesn't start ticking until until she's 18, right? So I guess if she became 18 in 2000, then the clock would, if she became 18 in 2000, then it looks like she just made it by 1 year. And let's go back, and it says, or within 20 years of the date person abused discover the use of reasonable diligence. Yeah, so it looks like 2015 is enough time for them to discover that they have been abused and subsequently filed the claim, right? So reasonable diligence discovered both that the act of childhood sexual abuse has occurred and that the injury was caused by the childhood sexual abuse. The fact that the person abused discovered through the use of reasonable diligence should discover that the act of childhood sexual abuse occurred is not by itself sufficient to start the discovery period. Okay, so yeah, so I mean, it looks like they're within the statutes of limitation because they're probably going to argue that number one, the abuse continued up into 2000, at which time she was 18. And then within that 20-year period, 2015, she discovered that she was damaged. So, that's the gist of that. It looks like she's going to have a solid claim. Again, I'm not a lawyer, and you can already see that I don't completely understand this. So let's just move on. Let's just move on from there.